Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. We bring in immigration updates. Along with me is now my business partner, Emily Neiman. Emily, now the serious things that is circulating in the community right now is all of a sudden the prevailing wages just went up on almost by 50% in most of the places. What about it? Is there any workaround about it? I mean, that's not a realistic wages. I mean, people don't get that much wages. Where do they come from?
Yeah, so this is, going from the 17th percentile to the 45th percentile that we talked about last week. We weren't really sure how quickly they would be updating the wages, but they were ready with them right away and got them updated, I think, last Wednesday. So a couple things to remember. This does not apply to perms that are already filed or prevailing wages for perm that have already been issued. It doesn't apply to LCAs that have already been certified or H1Bs that have already been approved. So this is going to be something that may be impacting people in the future, 3 years from now, if you recently got your H1B and are trying to file the extension in 3 years. But there are still some workarounds. Number one, we have an election coming up next month. Early voting just started here in Texas or here in Houston today. So those people that are eligible to vote, talk to your friends, tell them to vote. So that may change things. We are aware of at least 2 lawsuits that are in the works to be filed to block this because it really did blindside a lot of people the way they did it as an interim final rule without any ability to comment on it. You can't just all of a sudden tell employers they need to pay, a different amount when they've already offered people wages, they've already got things in the works, so it's just kind of very unfair of how they went about this. So litigation may be changing things, but on top of that, you don't have to use this wage data. There are private wage surveys that are still allowed. Nothing has changed about that. There are specific requirements for the wage survey to qualify, but there are lots of different options out there for these wage surveys. You usually have to pay for them, or the employer does. But as long as it meets the requirements, if the employer has an alternate, they can use that instead.
Wait. You're telling that it's not applicable to the current applications which have been filed, but future. So if I were to file the prevailing wage right now, in the perm application, then its new wages are applicable right now. And if I were to file a new H1B, that means if my H1B is expiring in the next 3 months, I didn't file an LCA, I'm subject to this new one. So are you telling that there is an alternative to it, that we don't have to use the dual wages, we can get an alternative, and have you done that, and what's the process for it?
Yeah, I mean, it's not really a new thing. A lot of people kind of just got used to relying on the DOL wage data, but you can use private surveys. Many people have been using them over the years. The survey itself has to meet specific requirements. It has to cover your specific job duties and spell out what the education is for the level that you're selecting, and there has to be so many people that are included in the survey itself, and it has to be the right area. Some of the things, and you have to fill out the LCA a little bit differently to mention that it is a private survey to get your LCA certified. Where it could come up, if we're now using a wage survey that is actually less than what the DOL level 1 wage is, you could see some pushback from USCIS by increased RFEs asking, is this really a specialty occupation? Because the whole point of the DOL wage survey change was to cut out the people that don't necessarily have the bachelor's degree or have less than a bachelor's degree as the minimum requirement. So, it's not without risk, and we don't know how USCIS will be handling these going forward, but in the past, they routinely accepted wage surveys, so it's not really anything new.
Emily, there's been a lot of things going on in the Indian community right now with the downgrading, EB3, EB2 downgrading, and the prior to date movements, and this prevailing wage increase, and then we have the new H1B regulations that are coming into effect in 60 days. That's telling that specialty occupation is becoming more tougher. And consulting companies, which, in the past 2-3 months, we've been getting H1B approvals like 3 years without much RFEs, though. It's been long that I've seen a H1B denial now, which last year, I used to see denial every day in our own office. I don't have to go outside the office to look into it. I don't even get any consultations now for the denials. Now they're telling that It's going to make tougher for the consulting companies. Now they have to get the incline letter and so on, the whole 9 yards. On top of all this one, now we have this students who are on OPT and STEM extension, especially students who are on the OPT, Emily. They seem to be targeted right now. If they don't inform the DSO that they are working for a particular company, though, their SEVIS is automatically getting terminated without getting any notice by them. Can you comment anything about it? What's the rules and regulations? What should the students do about it?
Yeah, so if you're in your first year of OPT, you do have that 90-day unemployment period, and that's always been there. However, ICE was not really looking into it or enforcing that on a very consistent basis. Usually it came up when you filed a change of status to H1B. Well, now ICE has routinely been looking in the SEVIS records, and if you fail to update that you've started employment with a new employer and it looks like in your record you've exceeded that 90-day unemployment period, they're just going in and terminating the record completely, not even giving you a chance to update. We did have advanced warning maybe about a month ago, I feel like. SEVP put out an alert stating that they were going to start doing this, and now we're seeing the results of that. So we're starting to see some students that have been had their record terminated, and they're going back to their school asking what can be done. There doesn't seem to be a way to do a data fix. For example, if you actually were working and didn't exceed the 90 days and just didn't update your record, you would think you would be given the opportunity to update it. That doesn't seem to be the case. It sounds like schools are telling the students to file I-539 application for reinstatement. But I don't think reinstatement works if your program has ended. Normally you can't do reinstatement to complete your OPT. Plus the processing time is so long, you're going to run out of OPT time anyway. So I don't think that's a good option. This is something that's just now started happening. So I don't know if you have any more information on that.
One thing is that I want you guys not only just drop an email to DSO that where your employment is, make sure that your DSO inputs that information into the SEVIS portal though. If the DSO forgets it, you will be in trouble.
I think most people now can update it themselves in the
Right.
SEVP side of the portal, so definitely check that and see what your record is currently showing.
Right.
For
If your
employment.
record doesn't show that you're employed, it's a good idea for you to update it and inform the DSO, and if needed, if any input needed from the DSO, you need to put that input from the DSO. And if you don't do it, you'll be in great danger. We started seeing some universities are getting kicked out right now for those people who are who did not inform that they are working with a company. Even though they are working, since they didn't inform it, they got kicked out right now. And when they approach the DSOs are not trying to help them that much because they don't seem to have an authority to help at this point of time. So please, anybody who is an OPT, please check your SEVIS system, check which company that you're working for. Is it reflecting in your SEVIS system? Can you update the system if you are, move from one company to another company? Or if you're unemployed, mention and you started working, you should mention it. Now, in the OPT period, there's no rule that you have to get paid. That is for the STEM extension. For the OPT, you could be doing an internship, an unpaid internship. And that's legally allowed in the OPT period, and it won't count towards your unemployment. So if you're doing some internships, please mention it in the SEVIS system, otherwise you'll get kicked out.
On that note, though, remember there are a lot of people that got caught in the situation of fake employment information.
No.
So please do not get caught in the trap of, this employer is telling me they'll just give me a letter even though they don't have a job for me. It needs to be actual work, valid employment. It can be unpaid, as you said, but it does have to be real work.
Of course.
So don't fall into that
Real work
trap.
or real training, either of those things
Right.
would be fine. Emily, new regulations. Ooh, this is a hot topic now. That's coming out in 60 days. Now, normally, the administration does give us time to comment, and based on the comment, though, they will allow us, and they will pass the regulations. But these people, especially Trump administration, they have decided what they want to do, and then they're asking our comment. I mean, that looks very ridiculous, though. Under some extreme circumstances, they do have authority, but I don't think so they have an authority in this way, the way they pass the H1B interim regulations. Of course, as Emily has pointed out, it will be challenged in the court, and if the court, we're expecting it in our favor, but if the court rules in the favor of Trump administration, according to the chief of the USCIS, 1/3 of all the H1Bs will most probably have to return back to India, Emily. That's what the statement that came out from him. I think so. This is going to impact especially the multinational companies coming from India. Those companies will be severely affected. One, because of the wage. Second, because of the documentation requirement. Not only the documentation requirement for the third-party placement, for the specialty occupation also, there is extra burden on the third-party placement companies as compared to the direct companies. So this is going to have a major impact on a lot of Indian nationals who work for third-party placement. Now, don't forget that the specialty occupation definition has also gone harder. So even if you are working for a direct company, though, they're going to make it more harder for you to get a H1B if this regulation goes out. I mean, any solution for it, Emily?
I think where the issue is if your degree is not directly related, if you've got a mechanical engineering degree but you're working as a software engineer, several years ago that was easier to get approved. It's been more difficult to get approved in the recent years, but it's probably going to become even more difficult. So you're going to be looking at getting new education plus experience evaluations to show that you have the equivalent of the degree that's directly related to the field. I think that's probably the biggest impact, as well as those particular fields or particular jobs where there are a number of fields of study, a range of fields that might qualify someone. Those are more likely to be targeted under this rule. And we also have, with third-party placement, the short-term approvals are only going to be approving for 1 year. So I think maybe some of those companies will move more towards using L visas where they can, which means people have to work outside the U.S. for 1 year before they're eligible. The L visas also don't have a wage issue, so that's another way these companies may still be able to work around the new wage surveys and the short approvals and the end client letters and all those sorts of things.
Lots of questions. I'll go to the questions. Some of the questions are Mavakul from YouTube has this question. Can we file I-131 and I-765 later after the 485 application for the EB3 downgrading? Yes, a lot of big law firms are actually not filing the 765s and I-131s right now. You can always file it. Question that comes up, so what if the priority date backtracks again? Still, you can file the 765 I-131. Once your 485 application receipt number has been issued, you are in good shape. I don't see that any problem for you at all in getting your I-765 and I-131.
Madan from Facebook wants to know about the downgrades and how people are filing those I-140s. He's hearing that some people's petitions are actually being returned by USCIS because it's a new petition and not an amended petition, and there's no labor certification.
Yeah, normally, Emily, what we do is that when we file a downgrade application, we put a note in there: do not reject before checking it with the supervisor. Especially when we file for an I-140 and adjustment of status, they don't see the I-140 approval, they don't see the priority date, and they immediately tend to reject it though. So I put a sheet in there saying, do not reject without checking with the supervisor. So I put those sheets before, we put those sheets, so that's the reason, normally, it's very hard for them to reject, because when you're pointing out, a lawyer is pointing out that we already know that they're going to reject it, and pointing out to the supervisor, that has a better chances of getting it accepted. The other thing, Emily, also, I think so that since this is a major thing, all of a sudden they're seeing downgrades, the officers might get a little bit more educated though. Maybe they will not reject. That's what I'm assuming. That
Yeah,
reject.
there's quite a number of people on here that have been hearing of rejections already, which would be very surprising to me since we're only October 13th. There's no way you file a petition October 1st and you're going to get the rejection back already.
But it was a norm for Emily that when you file an I-140 application, it was a norm, and when we filed for Chinese nationals, yeah, I did get 1 or 2 rejections before. I learned my lesson. That was probably about 10-15 years ago. I learned my lesson to put that sheet saying that. Maybe they're saying based on the previous experiences that they're getting rejected. Yeah, as you pointed out, they're taking 15-20 days, almost 30 days to issue a receipt notice. Within 15 days they get it back. I'll be very surprised though. Another question that is coming up on the YouTube and Facebook is, hey, do you file this application in a downgrade, or is it an amendment, or is it a new application? First thing, there is nothing called downgrade application at all. The second thing is that leave it to your employer, leave it to your lawyer. Why are you? I know that some of our audiences are lawyers. They come here to get educated, and I will suggest to those lawyers who are filing this application that you should not file this one as an amendment. You should file this as a new application. There are some rare circumstances where you have to use it as an amendment, particularly if, for example, if the company tax ID number has changed, if the company's identification has changed, and the new company is a successor of interest, those are the circumstances that I can think that you should file an amendment. Now, these are very technical terms, only intended for lawyers, not for the general public, because I see some of the lawyers also coming into this one to ask the question. So unless it is a successor of interest, no reason for you to put it as a amendment. Only in the successor of interest you should put as an amendment.
G from YouTube wants to know what is considered a third-party placement. I've been getting that question a lot as well. In the situation he gives as an example, the employer is the petitioner, the H1B is filed with a work location in the LCA, that's the client's location. Is that third-party placement? Yes, it is.
What if his company is an implementation partner?
I think it's still third-party placement if you are working at another company's location.
Let's say, for example, I am SAP programmer, or SAP person. I'm going to put this SAP into, let's say, for example, I'm going to work with Pepsi. And I'm not working for Pepsi. I'm just putting my software in their application to work. Is that still considered as third-party placement?
I think that's how USCIS looks at it. They don't recognize implementation partner. We've tried to make that argument before that there's no supervision being done by the end client. You just happen to be there because that's where the computer systems are. But anytime you're placed at another company's location that is not a party to the H1B, meaning it's not you and it's not your employer, you're somewhere else that's a different company, that's third-party placement. What is not considered third-party placement is you working from home. That's not a third party, that's you working at a different site, but that site is your home address. So that may be becoming much more common, working from home versus actually working at the client site, especially in the age of COVID where everyone's working from home still anyways. That may be one way to avoid those issues.
Question from Srikanth from Facebook. I have a traffic ticket which is a very meager amount of money. Do I need to mention in the 485 form? No, you don't have to mention in the 485 form. If the traffic ticket is a speeding ticket, and if that does not involve in any arrest, let me reiterate again, it's speeding ticket and not involve any arrest. Stop sign violations also do come under the same, you don't have to mention it. However though, if there is any DUI, if there is any arrest involved at any point of time, you definitely need to mention that thing. Also, any hit and run, definitely that has to be mentioned too.
Alan from YouTube wants to know, his wife does not have a social security number. How can she get a credit report? So she likely won't have one, or if she does, it'll say the score is 0. But you can just provide proof that she doesn't have one, which would be like a screenshot of you trying to enter her information and it saying no credit report found or something like that. That's fine. You just have to mention that on the 944 form.
Honey has this question. If I have an LCA certificate right now, can I use LCA right now? Can I use it right now, or do I need to file a new one? If you do have an LCA, funny, you can use it, and there's no reason for you to go back and file one more time. The Paperwork Reduction Act, does recommend you not to do that. I mean, there's no reason for you to do it again.
Manas from YouTube has an H1 that's expiring next summer and wants to know if it's possible to file the extension early before this rule goes into effect to get the 3-year extension. So you can only file up to 180 days before the requested start date. You may be able to file earlier by modifying the requested start date earlier. That's going to make your end date shorter, so you'd get 3 years from the earlier start date. But there is some risk there. People have had some issues in the past when they try to file the extension early. They say, well, you are already approved through this date. It's too early to file this extension. So it may have to be done as an amendment plus extension in order to file before the 180-day mark.
Kiran has this interesting question. He is an electrical engineer with 10 years of software engineering experience. With the new regulation, is it expected to have more hurdles? I definitely feel yes, you will have more hurdles. As Emily was pointing out, the mechanical engineer may not be applicable totally to you, Kiran, but still I believe that you will be in a little bit more harder position in getting the H1 approval with the new regulations as compared to the previous one. And I would suggest for the people like that if you have if you do think you fall into risk category though, or even if you don't, either of those things, before your I-94 expires, it's better that you get the H1B extension result. The reason, let's say for example, your H1B is expiring in December, and you file a H1B right now in premium processing. You get it denied, for example, in November, you can refile an H1B again. So you get 2 shots in there. But if you're going to file a H1B extension in November or December, RFE comes in January and you get a denial, you will be having very less options and very hard choices to choose at that point of time as compared to when I-94 validity is there.
Migo from YouTube has an I-140 that is pending right now, recently got an RFE, but the priority date is current and wants to know if it should file the adjustment of status now while the I-140 is still pending, or wait for the I-140 to be approved. So it really kind of depends on what your priority date is and whether it would still be current in November. If there's a risk that your date is only current under the filing dates chart, and we know once we find out that we can't use the November filing dates chart, then if you wait and get the I-140 approved, you may not be able to file the 485. So that's kind of the balance that you have to look at, is if you file the 485 and the I-140 gets unexpectedly denied, your 485 will get denied and you'll lose all of that money. But if you wait until it's safer because your I-140 is approved, you may lose your chance to file.
Why not from YouTube has this question, should we file I-944 for every derivatory dependent, derivatory applicant who's in adjustment of status? Yes, you'd need to. What about an 8-year-old kid? Do they need to file a 944 asking their assets and liabilities and their credit score? Unfortunately, yes, they need to file that one.
Krishna from Facebook wants to know what's going on with H4 and EAD premium processing. There was, a bill passed that allowed for that. When is that going to come into effect? So yes, Congress did pass a bill that specified that new types of applications can be eligible for premium processing, but in order for it to actually take effect, USCIS has to go through the regulatory process and set out what is going to be the fee, what is going to be the processing time. And I don't think they've even started that regulatory process yet. I doubt they'll do that before the election. So I wouldn't expect it to come anytime in the near future.
Kamal has this question that he has, the employer has refused to give the I-140 approval copy to him. He has filed a Freedom of Information Act and got a copy. Is that enough to file the H1B extension with company B? Absolutely, Kamal. No problem at all. You did a very good job of filing a freedom of information. That is good enough for you as much as having an I-140 approval. Even though the freedom of information, the document that you get doesn't have an I-140 approval, believe me, that has more value than I-140 approval. When we see that, oops, that is for us as an official copy. When it was filed, is it been withdrawn? Is it not been withdrawn? If it's withdrawn, is it withdrawn after how much time? I tell all the people though that even if they are working and they're nice companies and they're giving the I-140 approval, still get a freedom of information after 6 months your I-140 is approved. The reason is that you'll get an official documentation from the immigration saying that your I-140 has not been withdrawn according to their records after 180 days has been over. So that is a very good thing, everybody. You need to go to, just type in USCIS FOIA. You can fill the information out about your I-140. Typically it takes 2 to 3 months for you to get your I-140 petition copy.
Anil from Facebook wants to know how long it takes to get the 485 receipts after filing the adjustment of status. So right now it's about 2 to 3 weeks. I would expect after the October rush it's going to be more like 4 weeks. So I would not be surprised if it takes a month or longer to get 485 receipts for those people that are filing right now.
Ahmed Ali from YouTube, as my employer has been filed a premium processing. It's been a week. We have not received any receipt notice yet. Well, stay in line. They're taking a longer time just to issue a receipt notice right now. There's not much that can be done.
Naveen from Facebook wants to know if the current employer can file a perm and I-140 after an old employer has filed an EB3 adjustment of status. So, I mean, technically, yes. However, in order to take advantage of the new perm and I-140, you have to continue maintaining your non-immigrant status so that you can later file another 485 based on that petition.
Can my current company file perm and I-140 after my previous employer filed EB3 downgrade? That question comes from Naveen. Yeah, they can. There's nothing wrong with it. They can do so. Sanjeev from Facebook asked this question. Can I file I-485 with the current employer, but I have my I-140 approval with the previous company? The answer is no, you cannot. The company that got the I-140 approval has to file a 485J supplement unless they are filing for the downgrade. If they're just filing a regular thing, they have to file a J supplement. The company B, for which you are working right now, cannot sign the 485J supplement because they're asking if the original job offer, which was made for the labor certification, is still valid. That job offer was made to you, Sanjeev, by your previous company, not by your current company, so you cannot use that.
Shristi from Facebook wants to know if we get an EAD through this 485 and have to change work location with the same employer and don't file an H1 amendment, do you become married to the 485? Yes.
The word marriage is very good. Yes, you are. Yes. If you use the EAD, since you haven't let go the H1B, you will be married to the adjustment of status application. For those people who don't understand the word marriage in this particular sense, please go back to our 2 weeks ago video. It has the definition of what this marriage means. My computer's. Lots of questions with regards to the premium processing of the H4 and H4 EAD. Emily has already answered. Right now, the existing premium processings are only allowed for the premium processing. There is no H4 and H4 EAD premium processing at this point of time, although it is likely to cut pretty soon.
Niti from YouTube wants to know if a person is currently working with a wage level 3 LCA and it's time for the next extension, can the employer file with a level 2 wage? Most likely no. I mean, the level 3 wage is based on the education and experience and job duties for the position that were selected by the employer. The employer can't now say, oh, this is actually a level 2 job when they previously said it's a level 3 job, because the job duties and the minimum requirements for that job likely have not gone down. So I think that would be a problem.
My employee, Emily?
I mean, if it's truly a demotion, but then you're potentially looking at, is this really a specialty occupation? But I mean, if the job actually changes to where the requirements are less, and the job now qualifies for level 2, that is doable, but I would expect questions to be asked to make sure that that's actually what's going on. I know we have a lot of questions here. We're trying to get through them as quickly as we can. We did want to try to end a little earlier than normal today because we've just got a lot of our own clients that we're trying to get their 485s filed. So we've been very busy.
Amit is asking question, is it going to be 1 year or 2 year EAD? I mean, it's going to be, most probably it'll be 2 year, but we see about 10 to 20% of the time they might issue only 1 year EAD. This, he's speaking about 485 EAD.
Srikant from Facebook wants to know, if I've applied for the 485 and it's pending, can I change my employer before it gets approved? Is there any issue? Well, to qualify for AC-21, you have to wait for at least 180 days after the 485 is filed to be eligible to take your green card process with you to the new employer. This is assuming your I-140 is approved by that point as well, if you're filing a downgrade. To be eligible, though, the new job has to be same or similar to the existing job. So same type of job duties, similar occupation code. The salary can be different, the work location can be different, but the same core duties should be there. And then you have to submit a new Supplement J with that new employer.
Yeah, that Supplement J is very important though, because if you move to a different company, you don't submit the Supplement J, there is a chance that once the USCIS comes to know, they might deny the entire application. So be careful on those things. Don't move to a different company without filing a Supplement J. And please also look into consideration of marrying to the adjustment of status. If you use the 485J supplement and use the EAD, then you would be considered to have been married to this application. As Emily pointed out, that you can move to a different company after 180 days. Even though it's not a legal rule that the I-140 must be approved, it must only be approvable. I would be very careful. Since you guys are going with the downgrade right now, make sure the I-140 has been approved before you make any move out of the company. A lot of people are asking, can we do premium processing for the I-140 downgrades? We strongly suggest don't do premium processing right now. As soon as you get the receipt notice, I will tell you to do the premium processing, but not right now, because the mailroom gets confused with all those things and they will deny your application. They will reject your application, and it takes a long time. That's the reason file in the normal processing. We had a lot of experience with Chinese nationals where we had these issues.
All right. About time to sign off for today. Apologize for ending early. We need to get back to our regularly scheduled work. So we'll be back next week, and we'll keep you updated on all the new things that are going on in immigration.
Thank you very much for tuning in.